Hi, my name is Brittany Knight, and I will be presenting the expert testimony for Group 5, United Kingdom.
What are the legal challenges associated with cyber incidents involving foreign countries? How do internal laws affect e-discovery?
The main legal challenge that countries face in regards to cyber incidents is that cyber laws can differ from country to country. Data protection laws are governed by regions within a country, ultimately meaning that a legal process that is conducted within one country can be illegal within another. Internal laws can affect data retrieval techniques, data storage methods, and data analysis procedures for e-discovery. Each process must be followed according to the laws of the area, otherwise there is a risk of illegally handling private digital evidence. In order to ensure that evidence is handled according to the laws of the given country, it is important that a chain of command be implemented in all scenarios. It is also helpful to assess the relationship between the two countries to determine if the request for access to e-discovery would result in more serious repercussions.
What are the legal challenges of accessing and retrieving electronic evidence stored on foreign soil? Assuming cloud storage was used, what procedures were followed to access and retrieve digital evidence stored in the cloud?
The important thing to remember when attempting to retrieve digital evidence that is stored on foreign soil is that the laws must be followed in regards to where the evidence is stored, not by who is handling it. If the United States wished to access digital evidence that was housed within the United Kingdom, the United States must follow the legal procedures regulated by the United Kingdom. This further amplifies the importance of knowing what policies differ from country to country, and ensuring that emphasis is placed on studying a foreign country's policies before attempting any digital evidence retrieval. If the evidence is stored within the cloud, there are generally specific security requirements set by the original owner, which must be met by the digital analyst. Cloud storage devices can also be regulated by contractual guidelines, requiring both sets of parties to adhere to a previously established set of rules. Cloud data does present a challenge to digital forensic analysts, as it is seen as residing in virtual space instead of inhabiting a physical location. Although in technical terms this is true, it goes back to belonging within the jurisdiction of the original user.
Specific to the country that your team was assigned, how did the international laws and jurisdictions influence the processes and procedures followed during the forensic investigation?
The United Kingdom falls under the General Data Protection Regulation Law, or the GDPR, which demands a level of accountability and governance from those attempting to access private data. In regards to accessing data outside the borders of the United Kingdom, there was importance placed on understanding what laws and policies differed when analyzing data within other countries. Knowledge is the most crucial tool that can be implemented when conducting international investigations, as all other procedures safely fall into place when guidelines are clearly known. With the United Kingdom being considerably strict within their own policies, it made it easier when adapting to other countries, as the policies were somewhat less strenuous.
What conflicts arose between ethics and international laws during the forensic investigations? How did these conflicts affect the investigations? How were the conflicts mitigated or resolved?
The main ethical dilemma that arises with digital evidence collection is the act of accessing private data. Some forensic investigations have required viewing emails, documents, and written communication, all of which can be classified as private information. However, the rules and regulations that digital forensic analysts must follow protects both the privacy of the user and the intentions of the analyst. Digital analysts are bound to the laws that state only data that is pertinent to a case can be accessed or collected. International laws within the investigations did not greatly hinder analysis, as procedures were adapted to fall within the regulations of every region in which an investigation took place.
What steps were taken to protect the United States soil and citizens during the international investigation? Describe any risks to the country, businesses, or citizens from your investigations.
The United Kingdom, specifically with the ransomware attack, was determined to set a precedent for how to prepare against a cyber attack and also how to recover from one. The United States was not specifically targeted in this event. However, had the United States been a focal point of the attack, government agencies would have stepped in to better protect the country. For example, the FBI, Homeland Security, and other various government intelligence sectors would have stepped in to remedy the situation. As with any cyber attack or threat, the country, businesses, and citizens are faced with the threat of losing important private information. While individuals fear having their identity stolen, the country as a whole fears having national secrets or information stolen. The security of private information, no matter how great or small, falls on the shoulders of the cybersecurity community.